Thank you, President. Your Honor, we have a case which Mr. Esbrook does not currently have a lawyer. Brenda Allen appearing on behalf of the state, ALLEN, bar number 942352. This is on case number 16, CR 11512. Mr. Esbrook informs me that he wants to take a plea, but he's not willing to waive some legal rights. I explained to him that his choices are, 1, waive his rights, take a plea deal, or 2, we set up a trial. The state is not ready for the trial.
Yeah, and you're barking up the wrong tree here with me, Mr. Esbrook, because I follow the constitutional script exactly. So if you are going to change your plea or waiving your constitutional rights, okay, that are listed and enumerated in the plea petition, and if you don't understand that, you should be represented by somebody. So this case is getting long in the tooth. It is should be tried. So I'm going to either leave it on for trial, and you can plea on the day of trial, or you can go to trial, and that's going to be it.
I'm attempting to enter a plea today. It's not, I believe that the prosecutor has mischaracterized.
We're going to trial on this.
Objection. Okay. Do I have the right to a fair and meaningful hearing?
You are, sir, but I want you to listen to me very, very carefully, okay? Because this is important. If you have a problem with the plea offer or with your experience, or if you do not understand the rights that you are going to be waiving, then I can't accept the plea.
I don't know. I'm sorry.
In order for a judge to accept a plea of guilty or no contest, I have to make findings, and I have to make findings that the plea was knowingly given, that it was voluntarily given, and that there is a factual basis for the plea. Now, the knowingly given means that you understand each and every one of those constitutional rights, and I will go over them with you individually and say, do you waive this right? And if you do not respond, yes, I can't accept it. I just can't. And that it's voluntarily given, that you do not feel coerced, that you do not feel in any way boxed in, that this is your only choice, that I can't accept it unless I find that it's voluntarily given. And with regard to the factual basis, you have to make an admission that, for instance, if it's a, I don't know what kind of case this is, but if it was a theft case, that you knowingly took the property of another person with the intent to deprive them of it, it was a certain value, and you go through all that. All right? So, I am not going to give you legal advice, and I am not going to tolerate delays if I find that the delays are not in good faith. So, if you want to hire an attorney or want to apply for a court-appointed attorney and wish to go through that route, we can discuss that today and discuss what that would mean in terms of this case. If, however, you're going to say, well, I want to do this, but I won't do that, then we get into my explanation that I can't accept a plea on that basis. It's better that you go to trial. So, what is it that you desire?
Well, my desire is to be able to get this over with today.
Well, okay, but I don't want you to be getting it over with today and entering a plea of guilty when you're just when you don't think that you are guilty. In other words, a guilty plea is an admission. You're saying, yes, I did that, the allegations are true. And when people on a traffic ticket, if somebody comes in to me and says, well, I don't think I'm guilty, I wasn't speeding, but I just want to get over with today. That's not, I can't find that there's an actual basis for that, okay?
Right, I hear what you're saying, and I definitely understand that, but I did want to ask, do I have the right to be heard?
Well, you mean in terms of giving exculpatory information?
No, I mean in terms of not being interrupted while I'm trying to make my intentions clear to the court.
You are not being interrupted, sir.
I would say that the last statement that I was attempting to make, you interrupted me in the middle of it and didn't allow me to make my intentions clear.
For good reason, because I wanted you to understand the position of the court before you went on. But go ahead.
I am simply attempting to be informed of the cause and nature of these proceedings. I have not been arraigned as of this time, and I am attempting to be informed, and I'm just wondering if I have the right to be informed of the cause and nature of these proceedings.
Let me look here. And this is, what's the last four digits on this case? 2275?
11512. I can, Your Honor, with permission, I can put you in a little bit.
Well, I'm going to pull it up here. I'm looking for 11572 on this.
11512.
That's the book now.
Having March 1st, 2016 arraignment in front of Judge Todd.
And I would like to clarify that that was an arraignment attempt. However, a person who did not represent me began speaking on my behalf, and Stephen Todd entered or allowed her to enter a plea against my will and against my objections. And I made my objections very clear to the courtroom that I did not wish to be represented by any court-appointed attorney until I had been informed of the cause and nature of the proceedings. So I'm just wondering, do I have the right to be informed of the cause and nature of the proceedings?
You're speaking two different things here, Mr. Estabrook, and now I'm really concerned you don't know what's going on. Cause and nature of the proceedings is different than with regards to reservation of rights and the entry of the plea that you're referring to. Okay? And this is why I tried to interrupt you at the beginning, because I'm now concerned you're not listening to what people are telling you. You're going on a script here and not either because you are not cognizant and capable of understanding what is being told you, or you're choosing not to. So let me enlighten you, all right? On that date, March 1st, you were handed a true copy of the information, which is a charging instrument, a criminal charging instrument against you. And that charging instrument alleged that you, Robert Earl Estabrook, on or about February 28, 2016, in Multnomah County, state of Oregon, did unlawfully and intentionally refuse to obey a lawful order by a person known to you to be a peace officer. And that is contrary to the statutes such cases made against the peace and dignity of the state of Oregon. Also, that you, in count 2, on or about that same February 28, 2016 date in Multnomah County, state of Oregon, did unlawfully, intentionally, knowingly, and recklessly remain in and upon premises located at the Portland International airport screening area, contrary to the statutes in such cases made and provided, and against the peace and dignity of the state of Oregon. Now, with regards to these offenses, the maximum penalty on count 1 is up to a year in jail. It's a Class A misdemeanor, and or a $5,000 fine. On count 2, that is a Class C, and that means that the jail time is up to 30 days in jail and a fine of up to $1,250. All right? So, that is what you're charged with. The arraignment proceedings was for you to reserve all of the rights that the Constitution provides to you, which include your right to a jury trial, your right to confront, cross-examine all the state's witnesses and evidence. That means to determine whether it was appropriately gained, appropriately held, and appropriately used under our laws. That you have the right not only to confront and cross-examine your state's witnesses, but to do so with the assistance of legal counsel. That legal counsel would be appointed for you if you are not able to afford one on your own. Also, you're reserving your right to testify or not, based upon whatever you determine is appropriate in your case. You have the right against self-incrimination, and you also have the right of the state to prove your case beyond a reasonable doubt. That's the highest burden of proof in our judicial system. You don't have anything to prove. The state has that burden of proof, and it is proof beyond a reasonable doubt. You are presumed innocent unless and until the state can meet that burden of proof. Also, you have the right to examine before trial the evidence that the state is intending to use, and to go through the discovery statutes and glean from the state any evidence that they have, whether they plan on using it or not. So these are all rights that you have. And those are the rights that were reserved for you and go right with you all the way through each and every proceeding. Okay?
Do I have the right to counsel that is not paid for by the plaintiff?
The plaintiff in this case is the state of Oregon. All right?
Correct. And
you have public defenders, and that is it. We have two different agencies, the Multnomah County Public Defenders and Multnomah Defenders Inc. Okay? So that is who you have, unless there's a conflict of interest. If there is a conflict of interest, then in that event, they would hand it off to the other party, the other firm. Okay? They're very distinct firms.
Sir, is it not considered a conflict of interest if the public defender is paid for by the plaintiff?
No. Because the plaintiff is not paying for it. All right?
Is the plaintiff the state of Oregon?
The state of Oregon is the plaintiff, but in this particular case, the funds come from the general fund, and they are the taxpayers of the state of Oregon, and you might try to draw an inference that they're the same people, but they are not. These people are independent. All right? Just like you take an oath to tell the truth when you testify, they are bound to serve only your interest, no other interest. So it's up to you. You wish to avail yourself of the taxpayer-paid public defense, because no matter who you choose, even if it were an independent person, even if I called somebody who was an independent defense attorney and said, hey, could you come in here and help Mr. Estherbrook? They'd be paid by the state of Oregon taxmen.
I understand that, and I did want to ask, did I not on March 1st have the right to defend myself?
You have the right to proceed as defending yourself, and you still do.
And this is...
If I make a determination that you are capable of doing so.
And this is one of my questions then regarding that March 1st hearing and the claim that I have been arraigned. I was attempting to find out if I wanted to be represented by an attorney at the time, and I did not wish to proceed in a manner where I would be represented by an attorney which is paid for by the plaintiff. So I'm wondering how can you say that I was arraigned when I was not?
I don't want to argue with you, okay?
I'm not attempting to argue, sir.
You were just arraigned by me, okay?
Do you consider me informed of the charges if evidence of the element of jurisdiction is non-existent?
I am done with you. You're going to set this for trial, okay?
I object to that, sir. I do not wish to go to trial, and I have a relevant clarification I would like to make. Do you consider me informed of the charges if evidence of the element of jurisdiction is non-existent?
You can make a motion to dismiss for lack of jurisdiction, and if you want to make that motion, you can. And you can make it right today. But this is a pre-trial. This is not the time to make motions, and I would point out to you, you are improperly making the motion at this time because of the fact that if you're going to make that particular motion, there are certain times and places in this courtroom that you do that. But I will allow you to make that motion today. If you wish to make that motion today.
Well, point of clarification. I'm simply just trying to get a yes or no at this time.
I want you to make that motion. Are you moving this court to dismiss the case for lack of jurisdiction?
I will likely wish to make that motion.
I'm not giving you any legal advice. I told you that before. And quite frankly, Mr. Estabrook, I'm really suspicious about what you're doing here in this court. So, are you making a motion to dismiss this case for lack of jurisdiction?
Objection, point of clarification. I'm not sure why you're
Sir,
suspicious.
Mr. Estabrook, we're done. Set for trial.
Sir,
Your Honor, the state has a witness conflict at actual trial date, so I am requesting, this is the first step.
Well, I want it set over anyway because, Mr. Estabrook, I want you to really seriously consider.
I would tell the court that I talked to Mr. Estabrook when he was reviewing our discovery, and he did ask for an interpreter for interpretation of certain legal terms. I told him that's what a lawyer is for. I know Jay doesn't want a lawyer. Perhaps he would accept a legal advisor, which means he could use that person to interpret some legal stuff. But
I'm willing, Mr. Estabrook, to have anybody assist you because, quite frankly, I'm a little bit concerned that you're involved in some game or have got some advice that is going to get you nowhere.
objection, sir. I feel like that's unfounded. I'm simply asking for evidence of jurisdiction, and I would like to move to dismiss the case because the prosecutor has not submitted evidence of jurisdiction at this time.
Denied.
On what grounds, sir?
The court does have jurisdiction.
And what evidence are you relying on to substantiate that?
What I'm looking at right here with regards to the information that's sworn, we're all done here today. I want you to wait right there with a piece of paper.
I have a motion.
Sir, I object to having a trial.
We're all done.
I'm attempting to have...
You don't have to have a trial. You can take care of business by contacting an attorney, by changing your plea if I accept it.
Sir, I have not entered...
Mr. Estabrook, we're done. I'm entering a plea of not guilty for you. That has been done before. I don't really care right at the moment about whatever you're reading or whatever person gave you all this nonsense about the court. But I want you to understand something. I'm very concerned that you should get a trial attorney. Okay? You should go out, fill out, or at least hire some sort of legal counsel.
Sir, I would like to...
Mr. Estabrook, we're all done. Mr. Estabrook, we're all done here today.
Are you not bound by the Oregon Code of Judicial Conduct?
Right up here. Right up here, get your paperwork. We're all done, Mr. Estabrook.
Threatening me?
I'm not threatening you. I'm telling you you're all done, but I will have you escorted out of here if you do not cooperate.
I am attempting to cooperate. I feel as So you are violating my rights by entering pleas on my behalf against my will.
All
I'm
right.
only attempting to be informed of the cause and nature, and I would like to state for the record that I have not been informed as to the cause and nature of these proceedings.
We're all done, Mr. Estabrook, and you and I have a difference of opinion. Okay.
Just for the record, Mr. Estabrook, the new court date will be here on May 16th.
Objection, I cannot be here on the 16th, sir, and I cannot be prepared for a trial if that's what you're going to force me to do. If you're forcing me into a trial, I cannot be prepared until July.
If you were listening at all, it's a pre-trial date, and if you have a problem with the trial date, the pre-trial date's the time to raise that issue and to request a set over.
Well,
Okay, but this is my problem with you, Mr. Estabrook. You're not listening to what other people are telling you. You have some sort of agenda that you're following, and I'm concerned that it's not going to help you.
how is it?
All right, we'll see you back here on that date, okay?
How are you able to proceed with no evidence of jurisdiction?
We're all done here, sir.
I object, sir. I think you're violating my rights.
Objection overruled. Off you go.
What
And
rights?
please consider getting an attorney. We're all done.
I'm trying to make the determination of whether I can.
Officer, would you please escort Mr. Estabrook
I'll
out?
leave willingly.
Thank you.